Trademark law attorney here. Today, I would just like to say it's on, like Donkey Kong. That's what we're going to be talking about today. We're going to be talking about phrases as trademarks. My friend Brandon wanted to know, can somebody register a trademark for a phrase like, it's on like Donkey Kong? I don't even know why I like to say that. I just think it's hilarious. So that actually is a registered trademark of Nintendo Corporation. So what kind of things can serve as a trademark? Well, I've said it before and I will say it again. Anything that distinguishes one brand, one source of goods from another brand or another source of goods, another company's goods, can serve as a trademark. What kind of stuff are we talking about here? We're talking about colors. We're talking about phrases. We're talking about designs or logos. We're talking about taglines like, it's on like Donkey Kong. Every time I say that, somebody has to drink. Coffee or tea. I call this my big ass mug. You can drink every time I say it's on like Donkey Kong. Okay, anyway, so yes, anything can serve as a trademark, including it's on like Donkey Kong. Now, Nintendo, as I said, actually owns the mark it's on like Donkey Kong. It was applied for back in 2010, apparently anticipating some re-release of Donkey Kong. And it was filed as an intent to use trademark. Now recall that you can actually apply to register a trademark. You can file an application for a trademark without having used it yet. That is filed as an intent to use. So you have a bona fide intent to use the mark at some time in the future in commerce, even though you haven't started using it now. Why do people do this? They do it because they have an idea for a brand, they want to protect it, and they maybe want to develop the brand, or they have a product in mind, like Nintendo probably had a product in mind when they filed the application for It's On Like Donkey Kong. Now, they got a notice of allowance, which is basically the trademark office's blessing saying, we can't find any conflicts. We're going to publish this for opposition. The mark is then published for opposition. Anybody else that has a problem with the mark can object. And if they don't object, then the notice of allowance stands, and you have, if you apply for a registered trademark as an intent to use trademark, then you have 6 months to prove use. If you can't prove use in 6 months, then you file what's called an extension of time to file a statement of use. And you can file those up to 2.5 years, right? So you can extend that time for 2.5 years. You have to file a statement of use within 3 years of your notice of allowance. If you don't do that, then your mark, your application for that mark will lapse, and you'll have to refile. But you can basically kind of squat. I like to say there are no such things as squatters' rights in trademark law, and that's essentially true. But you can kind of squat on a mark for 3 years, right? 3 years plus however long it takes the notice of allowance to issue. So say 3.5 years, right? But eventually you're going to have to prove use by filing a statement of use with the trademark office. So that's intent to use trademarks. Yes, you can actually kind of squat on trademarks for a while. Now, what else did I want to? Oh, yeah, there's kind of a myth out there. I don't know where people are getting this idea that if somebody has a registered trademark for something that no one else can utter the phrase, and that's just not true. People can say it's on like Donkey Kong all they want, pretty much, as long as they're not using it as a trademark, or as long as they're not using it in a way that would cause people to assume that Nintendo is somehow associated with whatever is involved in their utterance. What do I mean by that? Let's say, for example, that there was a fast food restaurant and they wanted to promote their new Kong burger, right? It was a really big burger, kind of giant like King Kong. And they wanted to use the phrase, it's on like Donkey Kong. That wouldn't be allowed because it's on like Donkey Kong is kind of a famous phrase and it's associated with Nintendo. And it would give the impression, the false impression probably, that Nintendo and Donkey Kong were somehow associated with this fast food restaurant. That's something called dilution. I've talked about that. It's something that you deal with when you have a famous trademark, like it's on like Donkey Kong. That's probably pretty famous. So we don't want to give the false impression that Donkey Kong and this burger, the Kong burger, are somehow related. So that wouldn't be allowed. That would be considered a trademark infringement, that sort of use. But just uttering the phrase, it's on like Donkey Kong, isn't a trademark violation absent something like that, some kind of consumer confusion, some kind of false association, etc., etc. You get the idea. If you have more questions about that, please contact me. You can message me and find me online at TrademarkDoctor.net, or you can find my Facebook page, and if you like it, you'll be notified every time I go live. That's at facebook.com/TrademarkDoctor. If you like my page, you'll be notified every time I go live. And if you like this video, please go ahead and share it. I'll give you permission, and so does Facebook. This is Angela Langlots, and I will be back tomorrow again to talk about trademarks and business matters. Have a good one. And don't forget to drink.